So the Constitutional Court will on the 10th of May hear the IEC's challenge on former President Jacob Zuma's candidacy to run as a member of parliament for the MK party. Now the Commission is seeking clarity on its implementation of Section 47 of the Constitution. The section bars individuals sentenced to more than 12 months in jail without the option of a fine from contesting. But let's get some analysis on this, and for that we're joined by legal analyst Melusi. Melusi, good morning to you. This is just the most interesting case in a year as well, where we're seeing one of the most hotly contested elections since 1994. So the clock is ticking, and these clarifications need to be made in the court. We finally heard the reasons, Melusi, from Justice Dumisani Zondo as to why he ruled the way he did in the Electoral Court. And let me just read out what we've got here. Essentially, he found that the sentence imposed on a former president cannot be said to be a sentence with Section 47, and that's how he contemplates it. And then he goes further, saying that the former president was not afforded an opportunity to appeal the contempt of court sentence that was handed down by the Constitutional Court, and that's why we had the ruling from the Electoral Court. Was that a good assessment by Justice Zondi in your view?
Yes, I think the judges, when it comes to the issue of appeal, Naledi, it was a correct judgment, because let us look at it this way. Section 47, subsection 1, paragraph E says this objection does not apply if you are going to go through an appeal process on the sentence, or secondly, if the appeal process has not expired. Now, in July 2021, when the president was convicted and sentenced by the highest court in the land, it was impractical that he was going to appeal in any case. So I think that is the issue that the judges are having. So when it comes to the sentence being appealed, it was impossible, which then leaves a rhetorical question in this situation. And the rhetorical question is, was the Constitutional Court correct in sentencing him at the highest court? Because we've never had a situation in our constitutional dispensation where the court of first instance for a criminal matter is at the highest court. And I think the judges of the Constitutional Court will have an opportunity to explain that, because it's a big elephant in the room. And I'm saying this because if you go to Section 35, subsection 3, paragraph O of the Constitution, it says every accused has a right to appeal or review to a higher court. That is a constitutional right to appeal, but that right was taken away from the former president, and it leaves a bitter taste in the mouth. That's
very, very interesting. And then, of course, you've got the Independent Electoral Commission that has essentially, lodged this application with the Constitutional Court for that clarification around Section 47 of the Constitution. And then, of course, the question begs is that the role of the IEC to get that clarification? There's the criticism that has been shared by some pundits essentially saying that the IEC may very well be playing politics in the matter.
Yes, well, one may look at it like that and may have a problem where it's the IEC taking the matter to the Constitutional Court. But remember, they are using the constitutional provision, which talks about having a direct access to the Constitution, to the Constitutional Court when there's a constitutional issue that is being discussed. But their explanation was, which I kind of understand, was they want a clarification so that when the president is being laid in future, there will be no confusion. From my personal view or my wish, I did want this matter to go to the Constitutional Court, because I do think there was a question mark on how the former president was convicted and sentenced. Maybe the Constitutional Court will bring an end to the matter by clarifying how this came about. But yes, it does look like the IEC is taking a central role in the politics. But at the end of the day, the clarity needs to be done by the Constitutional Court.
So are you essentially foreseeing another victory for the MK party, even in the ConCourt?
Okay, I think there's been a lot of Constitutional Court cases that the former president has had, in particular to the arms deal matter, where he's lost most of those cases. Possibly this might be the first victory that we'll have if the constitutional provisions or the Constitution is applied as it should be. I foresee a victory, because what the Constitutional Court has to answer is, by convicting the former president and sentencing him in 2021, is it correct to say that that particular sentence applies to Section 47, subsection 1, paragraph E, when it cannot be appealed? And the question is, the answer to that is it can't be appealed. So it can't be that it applies to Section 47, subsection 1, paragraph E. And then it's back to my first question to say, was it really a proper constitutional sentence? Was it done the right way? If I had time, I would discuss the PW, former President PW Botha, where he didn't go to the TRC, but he was subpoenaed to go to a magistrate court where the trial was held, and he was present and was convicted. I think he had to pay a fine or a sentence. So this was what was expected. Hence, Advocate Mpofu has been asking, what is the case number? What is the case number? What is the docket? So this is the right time for the Constitutional Court to answer to that.
Yeah, it speaks to, I suppose, again, the opportunity for us to correct our judiciary processes, right, and get that right, particularly in a year when we're going to be watching very closely what such a critical arm of state is able to do. You agree, Melusi?
Sorry, can you repeat? I didn't get.
So I was saying, is when you speak about just the constitutionality of that conviction against the former president, one could argue that it's an opportunity for us to just look at, I suppose, the integrity of our judiciary as such a critical arm of state in such a big year.
Yes, we're having a test of our constitution, in particular to the decision that they made. But, you know, unfortunately, we expect as scholars and as ordinary citizens of the country that the Constitution cannot be a position or a platform where mistakes are made. But obviously, we will hear how the Constitution will examine itself, so to speak, you know, because there is a Latin term that says, I won't say it in Latin, but I'll say it in English, where it's asked, who guard the guardians? You know, they have to examine themselves. They have to examine their decision that they made in 2021, and I'm so happy that is being done, because I've always had a problem with the sentence that they did in 2021.
Yeah. Just as we wrap up, a final thought. I think just over the weekend, reports, of course, coming out that there may have been some fraudulent activity in how the MK was able to collect the necessary signatures that it needed for it to register for these elections. What are the legal ramifications of that? What are the steps that the IEC has a responsibility to taking to ensure that those signatures are legitimate?
Yeah, well, I think it's up to the IEC, and there's the gentleman that opened the case. I believe, I don't know whether he opened it in Western Cape. It's up to the IEC to take that and to check in terms of the Electoral Act of 1998 if everything that the MK had to comply with was done correctly. So let's wait until the IEC takes the decision on that. But obviously, it is a concerning issue, but it's the IEC who will once again, you know, examine that. It's just that it's unfortunate that for every second week or third week, there's something that the IEC has to discuss or to investigate with the MK. You know, one may think that MK is being targeted, but obviously, if there are issues, they'll have to be investigated.
All right, let's leave it there. Thank you so much for speaking to us. We really do appreciate it. To legal analyst Melusi Xulu there, who makes himself readily available to Newzroom Afrika, of course.